Hello everyone. Today we are doing the fourth video study session on industrial law, and that is industrial arbitration. So in the previous session, I told you that um, the main legislation in Sri Lanka that provides for resolution of industrial disputes in Sri Lanka is Industrial Disputes Act. And under Industrial Disputes Act, you can find mainly four mechanisms to resolve an industrial dispute. So we are talking about the third such mechanism available under the Industrial Disputes Act, and that is industrial arbitration. Okay, so now this lesson might be a bit, I don't know, long or confusing. So I think if we take the lesson as a whole, you can break this lesson into three main sections, and the first one is the minister's questions regarding the minister's power in relation to refer disputes to arbitration under section 4 subsection 1. Okay, and the second one is arbitrators scope of jurisdiction, powers and duties, and the third one is arbitral awards, like as in what does it mean by a just and equitable award, what are the effects of such award, and if one wishes to repudiate an award, what is the method he or she should take. So those are the three main areas we are going to study today. So yes, so let's start. Okay, so now we know under the Industrial Disputes Act, both the commissioner and the minister is imbued with the necessary power to refer an industrial dispute for arbitration. So the commissioner is imbued with the power to refer an industrial dispute for arbitration by section 3 subsection 1 paragraph D. So it's going to take a long time if I'm going to repeat this again and again, paragraph, subsection, section. So I'm just going to say 3.1D from here now on. So under 3.1D, the commissioner can refer an industrial dispute for arbitration only if the consent of the disputants or their representatives is received for such reference. And the arbitrator to whom this reference is made can be someone jointly nominated by the disputants, or it could be someone of commissioner's choosing, or it could be to a body of arbitrators or to a labor tribunal. Okay, so that's all regarding the powers of the commissioner to refer an dispute to arbitration, and we call this voluntary arbitration because the disputants themselves agreed to resolve their dispute through arbitration. Like the commissioner cannot refer an industrial dispute to arbitration which has not been given the consent of the disputants to refer it to arbitration. So like when the commissioner is going to refer a dispute to be settled through arbitration, getting the consent of the disputants is a must. Okay, so the minister, on the other hand, the minister is empowered through section 4.1 to refer industrial disputes to arbitration, to be settled through arbitration. Now, but the difference between the power of the minister and the commissioner is the commissioner can refer the dispute to be settled through arbitration with or without, notwithstanding the fact that the disputants do not consent to such reference. We call this compulsory arbitration because the consent of the disputants or their representatives is not needed. So with regard to this power of minister, like with this particular power, there's two questions that arises when you are reading the case laws related. So the first question is, can the minister refer a dispute which is already pending before a labor tribunal to be settled through arbitration? That is to say, now let's say I'm a workman whose services has been terminated unjustly, and I have made an application to a labor tribunal, and now the case is pending before the labor tribunal. But before the Labour Tribunal making a decision on that matter, can the minister refer the same dispute, same case, to be settled through industrial arbitration? Does the minister have power to do something like that? So in the case of Vimala Sena versus Navaratna, this question was answered in the affirmative. That judgment said yes, the minister has power to do something like that. But this case was overruled in Upala Newspapers Limited versus Exat Kamkaru Samitiya. So in that case, yes, so in that case, yes, the case was like the Vimal Sena versus Navaratna, it was overruled. The reason, the reason was in its judgment, the Supreme Court focused on three particular articles of the Constitution, and that is Articles 114, 116, and 170. So 170, Article 170 is the interpretation article of the Constitution. In that section, in that article, you can see various phrases and words being interpreted. So there you can find the interpretation for a judicial officer. Okay, there a judicial officer is interpreted to mean as a judge of the Supreme Court or a judge of the Court of Appeal. B, any judge of the High Court or any judge, presiding officer or member of any other court of first instance or tribunal or institution created for administration of justice or for the adjudication of labor or any other dispute. So when you so from that article, from that interpretation, it is apparent that president of a labor tribunal is a judicial officer, and Article 114 and 116 is regarding the independence of judiciary. Okay, so the combined effect of these three articles is that a president of a labor tribunal is a judicial officer. So if the minister is intervening in this judicial officer's work, that means his actions are in entrenchment of justice. Like he's interfering with the judiciary. Under constitutional law, the Sri Lanka the Sri Lankan constitution has the, what is it called? There's a separate separation of powers. We have separation of powers, and the three institutions, the judiciary, the executive, and the legislature, works independently of each other with a check and balance system in place. So if the minister is interfering with a judicial officer's work, he is interfering with the judiciary, and that is not something allowed. So the Supreme Court held that the minister's actions were in entrenchment of justice. Yes, so according to that judgment, it is now clear to you all that the minister cannot order for arbitration a case that is already pending before a labor tribunal. So the minister cannot refer my case to be settled through arbitration if it is already been pending. It is already been considered in a labor tribunal. Okay. So the next question is, can the minister revoke a duly made reference and make a fresh reference? There's arbitrator number 1, arbitrator number 2, and the minister makes a due, there's no mistake with the reference. He makes a reference to the first arbitrator in the due manner, but for whatever the reason, he revoke it and make a fresh reference to the arbitrator number 2? So this is the question you need to find the answer. You can find this answer in the judgment of the case Nadaraja Limited versus Krishna Dasan. So in this case, the Supreme Court in its judgment held that the minister has no power to revoke a duly made reference for arbitration, and the Supreme Court went on to specify events or like instances where making a second reference is necessary. Okay, so these instances are the first arbitrator may reject the reference. He may refuse to act on it, or this first arbitrator may have may have resigned from his position. He no longer works as an arbitrator, or he may have passed away or has become incapable of performing his functions, or he has left the country for a long time under the circumstances under which he left the country shows that you cannot expect him to return at an earlier date. So you have to see now, in this situation, if let's say the first arbitrator has died. Okay, the reason that the minister has to make a second reference is there's no arbitrator to act upon the first reference, because the arbitrator to whom the first reference has been made has passed away. So there's no arbitrator to act upon the first reference. So he's just merely making a fresh second reference to an arbitrator who is able to act upon such reference. Okay, so yeah, again, this difference, that is the revocation of a reference and the frustration of a reference was again differentiated in the case Equipment and Company Limited versus Ranasinghe. You can read through the judgment too. So okay, now the first section of the lesson is done. Okay, now we are moving on to the second part of the lesson, and that is the scope of jurisdiction, powers, duties of the arbitrator. So now let's first talk about the scope of jurisdiction of an arbitrator. So now any arbitrator has jurisdiction over references made to him under sections 3.1d and 4.1. So now that when a reference is made to an arbitrator for arbitration, it is followed by a statement from the commissioner. It is the reference is accompanied by a statement made by the commissioner listing out the matters or the matters that is in dispute between the disputants. Let's say there's an strike action going on in a company, and they are in this dispute because the workers are demanding for a raise in their salary. Okay, so when this dispute is going to be referred for arbitration, the commissioner is going to write a statement detailing why they are doing this strike action. In there, the commissioner will say they are demanding for a salary. Their salary has not been raised in this much of time. Blah blah blah. There will be the statement will it's sort of a report why they are having this dispute. Now the question arises: does the arbitrator's jurisdiction is it only limited to the matters stated in this statement? The answer to that can be found in the proviso to section 16. If the arbitrator is satisfied that that another matter which has not been stated in that statement of the commissioner, but he is satisfied that this particular matter is arising out of or is connected with matters referred to in the statement. If he is satisfied that there's matter A, this matter has not been stated in the commissioner's statement, but if I am the arbitrator, I am satisfied that this matter A is arising out of a matter stated in this statement, or is in connection with the matters stated in the statement. If so, I have jurisdiction over such matters too. I can consider, admit, make a decision on such matters. And now the next section that you need to draw your attention regarding scope of jurisdiction of an arbitrator is section 36 subsection 5. There it says the arbitrator can permit the disputants to raise fresh matters if he is satisfied that those matters could not have been raised at the beginning of the proceedings. That is to say, like when the arbitral proceedings are starting, the both of the parties like give their statements and they show their arguments, as in like they make their arguments and show like these are the reasons why we are in dispute. But towards the middle of the proceedings, like whether it be 2 days into the proceedings, 1 week into the proceedings, the arbitrator has the jurisdiction to allow any party to raise a fresh matter which has not been raised at the beginning of the proceedings, to raise it in the middle of the proceedings. If I am the arbitrator, if I am satisfied that such matters could not have been raised at the beginning of the proceedings, I can allow that party to raise it in the middle of the proceedings. It's okay. That is under section 36 subsection 5. So now, like earlier I said that when reading the proviso to the section 16, it is apparent that an arbitrator has the jurisdiction to admit, consider, decide on matters which have not been stated in the statement of the commissioner, but I am satisfied that they are arising out of or is in connection with matters stated in the commissioner's statement. So, in the case of Standard Chartered Grindley's Bank Limited versus Minister of Labour, in that case again, in that judgment, it was stated that that an arbitral award could contain connected matters in light of Proviso 16. That is to say, like if like the arbitral award could contain matter A, like the arbitrator's decision on matter A, the matter A I told you guys like earlier. Okay, so that is all regarding the scope of jurisdiction of the arbitrator. We talked about that the jurisdiction, like the arbitrator has jurisdiction over references made to him under 3.1d and 4.1, and we talked how the arbitrator has jurisdiction over connected matters stated in the Proviso 16, Proviso to section 16, and then we talked about section 36 subsection 5, and then we talked about the judgment in the case Standard Chartered Grindley's Bank Limited versus Minister of Labour. So now we are moving on to the powers of an arbitrator. The first section that you need to draw your attention regarding this is section 17 subsection 1. So in section 17 subsection 1, it says when a reference is made to an arbitrator, the arbitrator has the power to make all necessary inquiries into the dispute, hear all necessary evidences, and make an award that is just and equitable. So in short, the arbitrator has the power to conduct all necessary inquiries into the dispute. He has the power to hear to all necessary evidences, and he can make a just and equitable award. Decisions of an arbitrator is known as an award. So that is section 17 subsection 1. But then the question arises, now it says hear all necessary evidences. So in section 36 subsection 1 paragraph B, it says that an arbitrator has the power to require any person to give evidences before him. So if I am the arbitrator and I decide that there's this person whose evidence has not been admitted by any of the parties, but I think that hearing to that person's evidence is important, then I have the power to order him to present evidence before me. So yes, so that is section 36 subsection 1 paragraph B. So the effect of that section is an arbitrator is not limited to the evidences tendered by the parties. Like both the now I said in the previously that both parties do not present that particular person's evidence as evidence in proceedings, but I consider that person's evidence to be important to the case, so I have the power to require him to come before me and present his evidence. So now it's obvious that I am not limited by the evidences tendered by the parties. If I consider that I need more evidence, I can order a person to give evidence before me. So that is section 36 subsection 1 paragraph B. The next case is with regarding arbitral powers is State Bank of India versus Ediri Singha. In this case, in its judgment, it was said that an arbitrator is unrestricted and unfettered by the terms and conditions in the contract of employment, because that is as in if I am the arbitrator, I am not limited by the terms and conditions of the contract of employment. Those terms and conditions are not they are not restricting me from making an just and equitable award. I can make whatever the award I consider to be just and equitable, even if they are not compatible or compatible with the terms and conditions mentioned in the employment contract. So that was the case that is stated in the judgment of the case State Bank of India versus Ediri Singha. Okay, now the duties. There's not much, but in the Nadraja Limited versus Krishnadasan case, it was stated that an arbitrator has to listen to the evidences and look into the case and apply rules with judicial impartiality. That is you all know that an arbitrator is a third party. He is a neutral person, so he cannot be biased toward any party. So obviously that's what it says, that it is a duty of the arbitrator to act with judicial impartiality. Okay. So next we are moving on to the arbitral awards. So now I use the just and equitable phrase a lot in this lesson. The award of an arbitrator must be just and equitable. The award is something the arbitrator considers to be just and equitable to the both parties. So, but now there's this notoriety associated with the labor law in Sri Lanka, that it is biased towards the employees. It is true to an extent, I think, but it does not mean that every finding of an arbitrator, labor tribunal, or an industrial court has to be in favor of the employee. The phrase just and equitable, the mandate that an arbitrator requires to make, that is the mandate by which an arbitrator is required to make just and equitable awards, do not mean that it always has to be in favor of the employee. And that phrase do not give the arbitrator the freedom of a wild horse. He still has to act judicially, as in he has to act with judicial impartiality. So those were mentioned for this it was mentioned in the judgment of Municipal Council of Colombo versus Munasinghe. What I just said, that a just and equitable award does not necessarily mean a decision in favor of the employee, and that the arbitrator does not have the freedom of a wild horse. Those two things are mentioned in the judgment of the Municipal Council of Colombo versus Munisinghe. Now, now an arbitral award is made. Now, what are the effects of this award? You can find the effects of this award mentioned in section 19. Section 19 of Industrial Disputes Act. The effect of an arbitral award is the award is binding on all parties, related parties, as in like the disputants are bound by the arbitral award, and the terms and conditions of the arbitral award are implied terms and conditions of the contract of employment. So that's the effect. And in the case of State Bank of India versus Ediri Singha, it was again stated that an arbitral award seeks to create terms and conditions that are statutorily made implied terms and conditions of contract of employment. That is true, right? Now, like in section 19, it was stated that the effects of an arbitral award is like it is binding upon both parties, and the terms and conditions of the award is implied terms and conditions of the contracts of employment. So it was again reiterated in the judgment of State Bank of India versus Ediri Singha. So okay, now an award is made, but a party wishes to terminate this award. Like they no longer wishes to be bound by this award. Now, for a person like that, what are the recourses available under the Industrial Disputes Act? So in section 20, subsection 1 of Industrial Disputes Act, it is stated if a party wishes to terminate the award, that party can write a repudiation notice to every other party bound by the award and to the commissioner. Okay, and in section 20, subsection 2, paragraph A, it states that the award will be terminated upon the expiration of 3 months immediately succeeding the month in which the repudiation notice was received by the commissioner, or upon the expiration of 12 months from the date the award came into force, whatever is the later. So if the notice is whichever is later means as in if 12 months are fulfilled later than the expiry of these 3 months, then the award is going to be terminated at the end of the 12 months. But if the 12 months have already expired, then the award will be terminated at the upon the expiration of 3 months immediately succeeding after the month in which the notice was received by the commissioner. Okay. Now you can see in some of the cases you will see that the appellant party, you will see when reading the cases, the appellant party is sometimes requesting for a writ of certiorari. Now the question arises, is the writ of certiorari is that recourse available to these people? Because there's already a recourse available in the Industrial Disputes Act. That is the section 20, subsection 1, where it states an award is terminable, could be terminated by writing a repudiation notice to every other party involved and the commissioner. So in the case Obesekar versus Albert and others, it was stated that it is a discretionary power to award to grant a writ of certiorari, and that it will not be granted unless all other recourses available under the Act is exhausted. But later in a case, Fernando versus United Workers Union, it was stated that Section 20 subsection 1 does not disentitle a writ of certiorari. That is to say that so like in the judgment it was stated that the decision in Nobesekara versus Albert and others was wrongly decided. Like the section 20 subsection 1 do not disentitle a person from applying for a writ of certiorari. Okay, so that's that. So we finished talking about all the three like main sections for the regarding the arbitration part. That is the questions, the questions you see in case laws regarding the powers of the minister to order to refer disputes for arbitration, scope of jurisdiction, powers and duties of the arbitrator, and then the effects and how to repudiate an arbitral award. So we are done discussing them. So yeah, I hope this has been helpful, and like I'm just saying this as a tip, like you can make this sort of flow charts